Good morning, everybody, and welcome to day 2 of the Crammer. I am Demi Pretorius, and I'll be your host today. We have a very exciting lineup. But before we get there, just a few housekeeping rules. Please keep your mic and your camera off at all times. If you have any questions, just pop them in the chat box and I will raise them on your behalf to any of our speakers. We might not be able to get to all of our questions, but if that's the case, we'll make sure to get back to you in some shape or form, even if it's by email after the session. You are also welcome to leave any comments in the chat box. Then, if you missed yesterday's session, you missed out. Do yourself a favor and head to our social media platforms on LinkedIn, Facebook, YouTube. All the recordings of the sessions, yesterday's session, today's, and tomorrow's will be uploaded there. Yesterday, we had our guest speaker was Lindiwe Mazibuko, and she had a fascinating discussion on the link between leadership and branding. Denal van Deventer, one of our associates, shared a very neat summary of the latest trademark case law, and 3 of our partners shared some practical tips to use in practice. Today is also jam-packed. Our first topic is on mandatory vaccines, and it will be presented by Gilbert Marcus. My first and personal encounter with Gilbert was during my first year of articles when he accepted a brief from Adams and Adams to represent the public protector in what turned into a series of politically vital and precedent-setting matters concerning the powers of the public protector. I would describe him plainly as a walking encyclopedia, especially when it comes to matters of public law. Gilbert has been practicing as an advocate for longer than I've been alive. He's been a senior counsel since 1996. He has appeared in the Constitutional Court, I believe, almost 100 times, including in a successful challenge to the constitutionality of the death penalty, the striking down of laws that criminalized gay sexual relations, and compelling the government to provide antiretroviral drugs to pregnant women living with HIV. That's remarkable. I think I can think of no one more competent to answer the question I think is on everybody's minds, whether a compulsory vaccination policy would pass constitutional muster. Gilbert is in court today, but he agreed to sit down with one of our partners, Tando Manensa, earlier this week to debate the issue. Let's take a look at how that discussion unfolded.
Good morning, everyone, and thank you for joining us. The first topic of discussion today is regarding mandatory vaccines in the workplace. It is difficult to imagine an experience that human society has faced more profoundly than the COVID-19 pandemic. Almost immediately after the vaccine was declared a pandemic, the world's focus shifted towards the production of safe vaccines in the fight against the virus. Unfortunately, the initial optimism that faced vaccines has now been replaced by widespread skepticism. This division is unfortunately playing itself out in the workplace. The purpose of today's discussion is to get some insight from Advocate Marcus on mandatory vaccine policies in South Africa and how employers and managers out there can equip themselves in dealing with a very difficult and challenging issue that we are now faced with. So without further ado, I'd like to hand it over to Advocate Marcus for his discussion.
Thank you very much for inviting me to participate in this important seminar. Disasters are sudden, usually unforeseen calamities. They impact on countries in diverse ways, but inevitably they pose serious political, social, and economic challenges. The COVID pandemic vividly illustrates these challenges, and we experience its impact in our daily lives. It's probably fair to say that most of us know people who have died or who have been severely affected by COVID. We are reminded on a daily basis of the numbers of new infections and, tragically, the number of deaths, now, according to official figures, approaching 90,000 in South Africa and running into millions globally. The mortality figures in South Africa are very likely understated. While by no means minimizing the impact of COVID, some perspective is helpful. As horrific as a death toll of 90,000 undoubtedly is, it is relatively small compared to AIDS deaths in South Africa. Between 1998 and 2010, the lowest number of AIDS deaths in a particular year was 1998, at approximately 100,000 in that year. But those figures went as high as 275,000 in 2005, with similar figures over 200,000 in 2003, 2004, 2006, and 2007. There are, of course, differences in the responses to the AIDS pandemic and the COVID pandemic. HIV and COVID are differently transmitted. The former mainly through sex and blood, the latter through inhalation of an airborne virus. COVID, we know, is highly contagious and has a much longer life outside the body than HIV. In the case of HIV, the response was all too often driven by prejudice, stigma, and ignorance. It was impeded by denialists, which included our very own president. And it required the intervention of the Constitutional Court to compel the government to make antiretroviral drugs available. 40 years since the onset of HIV in South Africa, there is still no vaccine. The response to the COVID pandemic, both domestically and internationally, has been markedly different. There has been an unprecedented international scientific collaboration to produce vaccines in record time. And although there have been denialists and conspiracy theorists around COVID, these have not taken root in the same way as AIDS denialism did. This has much to do with the direction from our political leadership and the involvement of civil society. To his credit, the president has sought advice from the country's leading scientists, many of whom appear on television and explain to the public at large how the pandemic operates and what steps are being taken to prevent it. The science in relation to COVID is constantly developing. This is unsurprising since its manifestation is a very recent phenomenon. In recent days, the pharmaceutical company Merck has announced that it has developed a pill for the treatment of COVID, which it believes to be highly effective. We will have to see whether these claims survive the rigors of clinical trials and regulatory approval. What we do have at present are a number of vaccines which are effective in preventing COVID and minimizing its serious consequences, a matter to which I will return. Given the virulence of COVID and its widespread impact, the question of imposing compulsory vaccinations has emerged. When we speak of compulsory vaccination, we do not mean the forcible restraint of an unwilling victim while an injection is administered. We mean something conceptually very different, like making a vaccine a condition precedent for participation in various activities, such as employment or air travel or attending social events. In these types of examples, the question is whether it would be lawful to impose a requirement of vaccination before that particular activity may be embarked upon. In this way, the individual is given a limited choice: either get vaccinated or forego the activity in question. The answer to the question of whether compulsory vaccination would pass constitutional muster in these circumstances depends broadly on two questions. First, the justification for compulsory vaccination based on the availability of credible scientific evidence, and second, the balancing of competing rights. I don't suggest that these are the only considerations, but they strike me as being the main ones. Let me start with the question of credible scientific evidence. I'm not a scientist and cannot speak authoritatively on the science of COVID. I'm reliant on what the experts have to say. But for the purposes of this discussion, I make various assumptions. First, that vaccines are effective in significantly reducing the risk of contracting COVID, in significantly reducing the risk of hospitalization and death, and significantly reducing the risk of transmission. Secondly, I assume that having a vaccination entails minimal and insignificant risk to the patient. In other words, that vaccines are safe. It has been said that the risk of serious side effects to the vaccine is similar to the chances of being struck by lightning. And in any event, side effects can be treated. The third assumption I make is that the vaccines we have available to us in South Africa are manufactured according to internationally recognized standards. In other words, I assume that vaccines meet the requirements of safety, efficacy, and acceptable quality. These are, in fact, the statutory requirements which must be applied by the South African Health Products Regulatory Authority before it approves any medicine. The existence and availability of a vaccine is not in and of itself sufficient to combat the pandemic. In addition, vaccination on a massive scale is required, hence the question of compulsory vaccination, and it is here where legal issues intrude. Compulsory vaccination implicates at least the following rights. First, the right to freedom and security of the person guaranteed in Section 12 of the Constitution. It provides in relevant part, everyone has the right to freedom and security of the person, which includes the right not to be deprived of freedom arbitrarily or without just cause. And it goes on to say that everyone has the right to bodily and psychological integrity, which includes the right to security in and control over their body. Then there is, secondly, the right to freedom of religion, belief, and opinion, which is guaranteed in Section 15 of the Constitution. And thirdly, there is the right to fair labor practices, guaranteed in Section 23 of the Constitution and fleshed out in the Labor Relations Act. My focus today is not on the rights created under the Labor Relations Act. Our Constitution, like others around the world, recognize that no rights are absolute. So, for example, the right to freedom of expression does not mean that we can say what we like, where and whenever we like, without consequences. The right to life does not mean that the police cannot kill in self-defense in appropriate circumstances. So too with rights to liberty, freedom of religion, and fair labor practices. All of these rights may be limited, provided the limitation is reasonable and proportional. Our courts have developed careful tests to scrutinize the limitation of rights, to determine whether the limitation is justifiable, and they have regard to a variety of factors. Importantly, any limitation of a right must be sourced in law. In the context of compulsory vaccination, there are a number of potential sources. First, the Minister of Employment and Labour has issued a direction in terms of the Disaster Management Act on the 11th of June this year. That direction envisages compulsory vaccination in appropriate circumstances, and those directions were accompanied by guidelines for the imposition of compulsory vaccination. Secondly, Section 8 of the Occupational Health and Safety Act imposes on an employer the obligation to maintain a safe working environment without risk to the safety of employees. It requires employers to take reasonably practicable precautionary measures to ensure the health and safety of its employees. Section 9 of that Act imposes obligations in relation to members of the public. It requires that every employer is required to conduct their undertaking, and I quote, in such a manner as to ensure, as far as is reasonably practicable, that persons other than those in his employment who may be directly affected by his activities are not thereby exposed to hazards to their health and safety. And finally, our common law imposes an obligation on employers to ensure a safe working environment. So there is currently a number of potential empowering mechanisms which would permit compulsory vaccination, but the devil is in the detail. Public health professionals make a powerful case for compulsory vaccination on the basis that COVID is highly contagious and poses a serious health risk, while vaccines are effective in preventing transmission and mitigating the consequences of transmission. The impetus to get as many people as possible vaccinated is aimed at achieving various purposes. These include achieving herd immunity in an endeavor to prevent the virus from spreading throughout the population, to protect individuals from serious illnesses, to protect the health system from becoming overburdened, and to ease the current restrictions on movement and commerce. One of the requirements for justification where rights are limited is the adoption of less restrictive means to achieve the intended purpose. So certain companies, of which I'm aware, permit their employees to choose between compulsory vaccination or the provision of a negative COVID test every few days. And the Employment Equity Act permits medical testing, again I quote, if it is justifiable in the light of medical facts, employment conditions, social policy, the fair distribution of employee benefits, or the inherent requirements of a job. So, in short, there is, in my view, a powerful justification based on scientific evidence for compulsory vaccination. The idea and implementation of compulsory vaccination is not new. More than 100 years ago, the United States Supreme Court dealt with a challenge to a law requiring compulsory vaccination for measles. The United States Supreme Court rejected that challenge in a case called Jacobson versus Massachusetts, decided in 1905. The terms of the majority reasoning are important, and let me quote to you what the justices said. They said the following: the defendant insists that his liberty is invaded when the state subjects him to fine or imprisonment for neglecting or refusing to admit to vaccination, that a compulsory vaccination law is unreasonable, arbitrary, and oppressive, and therefore hostile to the inherent rights of every free man to care for his own body and health in such a way as to him seems best, and that the execution of such a law against one who objects to vaccination, no matter for what reason, is nothing short of an assault upon his person. And here's the important part. The court went on to say this: but the liberty secured by the Constitution of the United States to every person within its jurisdiction does not import an absolute right in each person to be, at all times and in all circumstances, wholly freed from restraint. There are manifold restraints to which every person is necessarily subject for the common good. On any other basis, organized society could not exist with safety to its members. Society based on the rule that each man is a law unto himself would soon be confronted with disorder and anarchy. Real liberty for all could not exist under the operation of a principle which recognized the right of each individual person to use his own, whether in respect of his person or his property, regardless of the injury that may be done to others. So what you see in the reasoning of the majority of the United States Supreme Court is that balancing between individual rights on the one hand and the collective good on the other. In reaching the conclusion which it did, that the compulsory vaccination law thereunder challenge was not constitutionally offensive, the Supreme Court recognized the need for certain safeguards. There were three. First, the implementation of the law could not be exercised in an arbitrary or unreasonable manner, or go beyond what was reasonably required for the safety of the public. Second, the means used must be proportionate to the purpose. There must be a real or substantial relation to the protection of public health and safety. Third, the measure should allow exceptions to those who face bodily harm from vaccination. To require vaccination of a person who would be harmed by it would be cruel and inhuman. Now, I suspect that a similar approach would be adopted by our Constitutional Court should such a case come before it. The Constitutional Court has certainly adopted a similar approach in the context of freedom of religion. It has recognized, for example, that a deeply held religious conviction, which would permit the imposition of corporal punishment in schools, is simply not compatible with the Constitution, and hence it is prohibited. In short, therefore, I'm of the view that a carefully tailored compulsory vaccination program, which respects the rights of employees and permits of exceptions, is likely to pass constitutional muster. Such a case has yet to reach our courts. However, I should in conclusion mention one High Court matter which concerned the constitutional legitimacy of coercive measures adopted to combat TB. What happened in that case was that the MEC for Health in the Western Cape applied to court for the compulsory admission to and continued isolation at a particular hospital of certain patients who had been diagnosed with highly infectious, extensively drug-resistant tuberculosis. The medical evidence presented to the court demonstrated that this form of TB was highly infectious and dangerous. It had been described as a serious global health threat for which there was no proven regimen of treatment. This meant that contact between the infected patients and anyone else posed severe health risks. In the result, the court permitted the compulsory isolation of the affected patients until such time as they had reached the point where they posed no health risks to others. To be blunt, this amounted to detention without trial, albeit in extraordinary circumstances and in an endeavor to prevent major health risks. Now, this was only a decision of the High Court. Neither our Supreme Court of Appeal nor our Constitutional Court has pronounced on similar matters. But I think it is only a matter of time before the Constitutional Court is called upon to consider the legitimacy and legality of compulsory vaccination. Thank you very much.
Thank you very much, Gilbert. I think that was a very insightful discussion on a very, very complicated topic. And there's no doubt that I think it's going to be important for a lot of our clients and a lot of people out there to hear what you have just said. I think you spoke a bit about some of the duties for employers that they're faced with, especially in terms of the Occupational Health and Safety Act. And the first question I would just like to ask you is, what should employers do if they want to legally enforce a mandatory vaccine policy in the workplace?
Well, I think that the starting point would be to take the cue from the existing current disaster management directions. And I think that it would include at least the following. First, I think there would have to be a risk assessment. And there is no one-size-fits-all approach. It necessarily requires a consideration of the nature of the work activity and whether it involves the necessity to work in close proximity to others and in a confined environment. Underground mining is a good example of both close proximity and a confined environment. But of course, work requirements and workspaces differ markedly. So the assessment of risk is inextricably linked, I think, to the operational requirements of particular enterprises. Secondly, I think that employers need to develop a plan to meet the risk. And again, there is no one-size-fits-all approach. Wearing masks and social distancing may be sufficient, together with protective screens and divisions and sanitizer stations. The plan might include, where appropriate, the permissibility of remote work, with which we have all become accustomed. Thirdly, I think there is a critical need for consultation. I would regard this as fundamental. There ought to be consultation with the workforce and particularly trade unions who are representative in the particular trade or industry. The approach, I think, should be a collaborative one in an endeavor to find a common solution in both the best interests of workers and their employers. The prize, in my view, would be to negotiate a mutually agreed program for compulsory vaccination. Fourthly, there's the need for flexibility, which I've already touched on. Employers should seek to accommodate genuine objections to being vaccinated, which might include medical reasons or religious reasons. The latter, of course, poses certain difficulties, but where, however, it is possible to accommodate exceptions, this must be done. Fifth, there is a need to facilitate the application of the vaccinations in as easy a manner as possible. So employers should ensure that there are adequate measures in place to assist their employees to get the vaccination at no cost. This would include, for example, providing transportation to vaccination centers. Sixth, I would identify the need for proper and clear communication. One of the guidelines under the disaster directions requires that every employee should be properly notified of the obligation to be vaccinated, as well as the right of the employee to refuse to be vaccinated on constitutional or medical grounds. The directive also requires that employees be given the opportunity to consult with a health and safety representative or a trade union official. In broad terms, what I'm saying is that employees should be given all the necessary information to enable them to make an informed decision. Lastly, the policy should also deal with refusal. The current disaster guidelines impose obligations on an employer. Should an employee refuse to be vaccinated, they require the employer to first provide the employee with counseling and permit the employee to consult a health and safety representative, workplace representative, or trade union representative. Second, the guidelines require that the employee may be referred for further medical examination should the objection be based on medical grounds. And thirdly, it imposes an obligation on the employer to reasonably accommodate the employee in a position that does not require compulsory vaccination. I would think that these are the essential steps to be taken before imposing a regime of compulsory vaccination in the workplace.
Yeah, thank you for that. I would agree with that. I think dealing with it in those steps in that practical way is of great assistance. I think you touched on at the end there regarding refusal of an employee, and that's a topic that we'll discuss in a moment. But I want to just touch on the role or the response that the judiciary has had with in dealing with this pandemic. We obviously are in a country that as compared to maybe first world countries, is highly influenced by trade unions. So the way that the court has maybe dealt with the COVID-19 pandemic might inform how they deal with potential refusals of employees. So perhaps maybe you can just give us some of your insights into how the judiciary has dealt with COVID-19 cases that it has faced thus far.
Certainly. I think your question entails two components. The first is the impact of COVID on the functioning of the courts themselves. And the second is the attitude of the courts to various legal challenges to the lockdown regulations. As to the first, the courts and the legal profession as a whole, as I'm sure everybody participating in the seminar well knows, has had to adjust because of the pandemic. The most obvious and tangible impact has been the conducting of remote hearings in court, including our highest courts, the Supreme Court of Appeal and the Constitutional Court. Virtual hearings are today the norm. And to the surprise of many, they work particularly well. The courts have certainly managed to fulfill their judicial obligations without the need, in most cases, for in-person hearings. As to the second part of the question, I think that there are a number of trends in the attitude of the courts to the legality of the COVID regulations which can be discerned. Obviously, in answering your question, I speak at the level of generality, but I do think it fair to say that one can identify at least the following trends. First, the courts have shown a very high degree of deference to the state's choices of measures to conduct the pandemic. They recognize the severity of the threat posed by that pandemic and the need for the state to take appropriate measures to combat the pandemic. And they have been prepared to grant the state a considerable leeway in the measures that have been adopted. In the manner that I've explained at the outset, the courts have recognized the need to balance individual rights against the need for collective health and safety. And in the main, they have recognized that the collective good must prevail, even though there are limitations on individual rights. Secondly, in the broader scheme, very few challenges to the disaster regulations have succeeded. Most have been rejected. Constitutional Court has yet to pronounce on the topic, but there have been a number of cases which have gone to the Supreme Court of Appeal, and those have been largely sympathetic to government endeavours to combat the pandemic. The courts have repeatedly indicated that their role is not to second guess the choices, the difficult choices that government faces in matters in a time of crisis. Their role is really limited to ensuring that the government's response falls within the range of permissible legal limits. Thirdly, I think it is fair to say that the state, the government, has become increasingly adept in defending such challenges and putting up the necessary evidence. That was not necessarily true in some of the earlier cases, but that has changed. Fourthly, those challenging the disaster regulations seldom come away with tangible results. This is because the courts have the power to suspend any orders of invalidity, to enable the state to rectify any defects which they've identified. And in addition, if the state fails in a particular matter and lodges an appeal, the effect is that the decision in question is suspended pending the outcome of the appeal. So in short, parties are fast learning that challenging the disaster regulations is a risky enterprise, and which, even if successful, often produces no tangible benefits. I should stress one further thing, however, and that is that, at least in theory, measures taken pursuant to the disaster are meant to be of temporary duration. But it is now 19 months since the first lockdown in March 2020, and it appears that we have a way to go. So there are justifiable concerns that what were envisaged as temporary measures cannot go on indefinitely.
Thank you, Herbert. I guess, I think the point that you made regarding the deference of the courts is quite an important one, and in informing maybe how the courts are viewing this whole pandemic. But I guess for us and most of the people, most of our audience, the real question that they are going to be faced with is how to deal with an employee that refuses to comply with a compulsory vaccine policy, and practically to deal with that. Sometimes it might be difficult to imagine it outside of from a court context, but practically when you're at the office with employees that are refusing to comply with the policy, how do we deal with that?
Well, I think that if a company adopts a compulsory vaccination policy along the lines that I have suggested, then the question inevitably arises as to what the company can do should an employee refuse to comply with that policy. I've already indicated that any policy should be flexible and should try as far as possible to reasonably accommodate those who have a genuine, and I stress the word genuine, objection to being vaccinated. So the starting point, I think, would be to determine whether the objection is genuine. If the objection is on medical grounds, that can be verified by medical examination. Other objections based on claims of freedom or religious belief are more difficult. But it seems to me that an employer would be perfectly entitled to interrogate those reasons to see if they are genuinely and consistently held. For example, an employee invoking a general right to freedom may well be asked whether he or she wears a safety belt in their motor car, and that would certainly be inconsistent with a general claim to freedom. Or whether such an employee wears a hard hat on a construction site. Again, I'm simply using those as examples to see whether the belief or the claim is honestly and consistently held. But I think regardless of the nature of the objection, counselling would be a first port of call, and that is suggested in the current disaster management directions. And that would be aimed at seeking to persuade the recalcitrant employee to accept a vaccine in circumstances where reasonable accommodation is simply not possible. But I think that employees need to face the reality that the point may be reached where a refusal of a vaccine as a condition of continued employment and in the face of a reasonable compulsory vaccination policy will have to be met with disciplinary action. Now, in broad terms, this would entail a consideration of the detailed requirements of the Labour Relations Act, which is really beyond the scope of my talk today. I venture only certain general comments. First, the procedural and substantive requirements of the Labour Relations Act will have to be complied with. Broadly speaking, this means there has to be a fair procedure and a substantively fair reason for any disciplinary action. Second, the employer should seek lesser means or means short of outright dismissal in relation to the particular employee. For example, the employer might consider retrenchment, which would at least require the payment of a certain amount for years of completed service. And then the employer must consider options short of dismissal. Dismissal is the most serious sanction in the workplace. It's been described by our courts as the death penalty in a labor law context. And so measures short of dismissal should obviously be contemplated and applied if possible. But it must be accepted that the exhaustion of the requirements that I've mentioned may ultimately, depending on the particular circumstances, result in dismissal.
Thank you, Gilbert. I think from your discussion, the key takeaway I would take is consultation. Just constant speaking and being transparent with what you want to do as an employer, rather than just taking a more dogmatic approach. Right. But thank you very much for joining us. We really appreciate it, taking time out of your busy schedule. And I really hope that our audiences and our clients have taken out some practical suggestions from your talk.
It's a great pleasure. Thank you for having me.
All right.
Some of you may have experienced a few delays or breaks in that video, and we apologize for that. And thank you for staying with us. Thando, thank you for joining us. That was a mouthful. You've now had a day or two to digest Gilbert's arguments. Can you very quickly sum up the key takeouts, and perhaps while you're doing that, just clarify one of the questions that one of our guests have, which is, what if an employee is claiming that they have a medical condition and it is impacted by the vaccine? Unfortunately, due to fake news, we can't conclusively say it won't. So how do we address this?
Thanks, Demi. Yeah, it is a very complicated topic. It was quite a mouthful that Gilbert discussed with us. But I think for me, the major takeaway is firstly that our constitution is strong. We've dealt with health crises in the past, and our courts, to the extent that it's necessary, are well adept at dealing with such issues. So I think we must not lose faith in our constitution and understand that we've got the necessary laws in place to deal with an issue like this. But I think the second big takeaway, beyond the steps that Gilbert gave insofar as the practical application of these policies, is that consultation with your workers is important. This can't be, to the extent that a mandatory vaccine policy is going to be implemented, it needs to be done with a lot of consultation, a lot of discussion, so that each party understands what their rights and obligations are, and each party can, navigate their way out, navigate their way through this. This is not a very simple topic. It's not a very simple subject. So I think the primary important thing is to consult and be well aware of the principles in the directive that was issued by the Labour Department. I think that's quite key. So insofar as the question of what to do if an employee is claiming that they have a medical condition that prohibits them from taking the vaccine. I think that is quite well dealt with in the directive that Gilbert and I have just spoke about in the discussion. That can be easily ascertained through medical examinations to make sure that the claims of the employee are actually true and correct. So I think that those are the major takeaways, and I really hope that everyone enjoyed it.
Thank you, Tando. I think that we have a minute or so left, and I'm just looking at a question from Yolandi James, which was covered to an extent in your and Gilbert's chat, but it's slightly different in the sense that she asks, what about when an employee refuses to be tested for COVID-19, whereas in the discussion we focused more about on the refusal to get a vaccination, to get vaccinated.
Yes.
Can you just give us a short answer on that?
Sure. I think the starting point is to understand, as an employer, you have duties to create a safe working environment in terms of our common law, in terms of the Occupational Health and Safety Act. So the implementation of policies that give effect to that duty, provided obviously that you have gone through the lawful processes and there's been consultation, those policies will always be lawful. And if an employee on the one hand refuses to take the vaccine, but at the other hand refuses to comply with a lawful employment policy, you can then take disciplinary steps against that employee.
Yes. Okay, so policies should be flexible, not coercive, and hand in hand with consultation, I think, goes educating employees about the risks and advantages of the COVID vaccine and why it's important to get vaccinated.
Yeah. If I can just say quickly, Demi, I think it's important just to understand, even in terms of the directive, it does say that you need to educate your employees. This can't be something that is just simply imposed. There needs to be consultation, there needs to be an educative process to them before the implementation of the policy.
Thank you, Tando. There you have it, everybody. I hope that has clarified some of your questions. We will now turn to our next topic. Our presenter is Eliza Volmans. Eliza is a bright young associate, and she will be discussing the recent Constitutional Court case, which resulted in former President Jacob Zuma being sentenced to prison. Whenever you are ready, Eliza.
Thank you, Demi. I appreciate the introduction. Just want to make sure everything is fine. So, justice. I want you to think about your definition of justice. What if I submit to you that each of us, given the opportunity, would be able to write out our definition of justice without needing a lecture on it? I say so because it's inherently part of our DNA. Justice is the quality of being fair and reasonable. During the deeply unjust past of South Africa, there was a cry for something, for a vehicle of change, and this was found in the Constitution. Subsequently, the Concord was born in 1994 with South Africa's first constitution. Therefore, today it is a privilege for me to discuss the Concord's leading role in the administration of justice during former President Jacob Zuma's contempt of court proceedings. During the next 10 minutes with you, I hope to discuss two main questions. How did the Concord get involved, and what does it mean for the future of contempt of court proceedings? So how did we get here? How did the Concord actually get involved? I think the appropriate starting point is to make sure that you have a firm understanding of what contempt of court is. Contempt is basically a crime where an individual unlawfully and intentionally disobeys a court order. The test for this type of disobedience is whether the contempt was committed deliberately and mala fide. It is then for the perpetrator to establish that there is reasonable doubt as to whether the non-compliance is willful and mala fide. In step with the celebrated words of Justice Brandeis, if the government becomes a lawbreaker, it breeds contempt for the law. It invites every man to become a law unto himself. and that invites anarchy. So how did the Concord get involved? I wish to share this timeline with you, and if you can just give me a moment of your attention, I'll just walk you through it. Zuma's woes started in November 2020 when he decided to walk out of the Zondo Commission without the chairperson's permission. This led to the Concord in December 2020, bringing an urgent application before the Concord, seeking an order that would in essence compel Mr. Zuma's cooperation with the Commission's investigations and objectives. In January 2021, the Concord ruled in favor of the applicants and basically compelled Mr. Zuma to comply with the summonses and to attend the Commission. In February 2021, sorry, let me take a step back. In response, Zuma released a public statement in which he directed considerable criticism towards the Commission and the Concord, stating that both were victimizing him through exceptional and harsh treatment. Therefore, in February 2021, Zuma failed to appear before the Commission, and this was after being served with summons. On the same day, Mr. Zuma published another statement in which he leveled serious criticism against the judiciary. And there he confirmed that he would neither obey the court order nor cooperate with the Commission in any respect. Therefore, in March 2021, the Commission requests Zuma to answer to allegations made against him. But Zuma misses the deadline to file his answering affidavit to the Concord in his contempt of court proceedings. It is these regrettable series of events that led to the State Capture Commission's urgent application to the Concord seeking Zuma's arrest. And in April 2021, April this year, the Concord sentenced Zuma to 15 months in prison. Zuma then made a rescission application against the court, which was heard in July 2021, and the Concord took more than 2 months to make a decision. What emerged was, in fact, that the court was split 3 ways, 1 majority judgment with 2 minority judgments penned. Currently, Zuma is out on medical parole. So this leads me to my next question, or the natural next question. What now? What does this mean for the future? To answer that question, we need to understand the legal landscape before the Zuma hearing. Contempt of court is not only directed against the perpetrator, but it also serves as a remedial measure aimed at restoring the dignity of the court, protecting the integrity of court orders and the court system. Generally, the way one restores is by means of a coercive order. And what that basically means is that one would give the perpetrator X amount of time to comply, failing which the sentencing will be imposed. So it is common knowledge that a person guilty of contempt of court was very rarely given a punitive order of direct imprisonment. The position in South African law has always been that an unsuspended committal order that is purely punitive should be the very last resort. So then the answer to this question, how did things now change? Well, first of all, the Concord protected the finality of proceedings. As Judge Campepe said so well, like all things in life, like the best of times and the worst of times, litigation must at some point come to an end. Secondly, this Concord decision created precedent. Every time a court decides on a matter, it not only settles the issue in dispute, but also creates precedent. That happens because the Concord's interpretation of the law in one case sends out a signal how the court would likely interpret the law in the next. So when you look at the majority judgment and when you consider the content of the majority judgment, it becomes clear that the court relied heavily on aggravating factors when determining the appropriate sanction in this contempt of court proceedings. It is noteworthy to point out that aggravating factors do not form part of the common law requirements for deciding whether someone is in contempt of court. The Commission, as the applicant in this matter, made a very good case for a punitive order and argued that it is appropriate in this matter because it involves unique and aggravating circumstances. And for that, there is no meaningful precedent. So although the majority creates a precedent for future contempt of court cases, it should be noted and understood that Zuma's case had a lot of unique aggravating circumstances which influenced the judge's decision. Another point of future to note is that this Concord decision oiled the wheels of justice. The Concord dealt with the matter firmly, and this was required for a matter of this nature. The majority judgment concluded that it would be contrary to the interest of justice to expand the grounds of rescission, which Zuma requested at the end of the matter. The Concord made it very clear that the legislature has deliberately carved out exceptionally narrow grounds for rescission because the notion of rescinding court orders. This is very important because to just readily set aside any court order would not be in the heart of administration of justice, and the administration of justice would be compromised by chaos. Another good thing about this judgment is that we have a dissenting judgment. So the dissenting judgment is the two minority judgments where one or more judges disagreed with the majority judgment. Their importance cannot be denied because more often than not, they actually plant seeds for future change in law. It allowed for a very good structural judicial dialogue. It provided an additional measure to hold judges accountable, and it fostered judicial transparency. But the counter argument is that the effect, however not the intent, of the dissenting judgment is that it created this false impression that former President Jacob Zuma was a victim of a grave and unconstitutional injustice. So in conclusion, given that contempt of court is very fact-specific, the remedial action must always follow the facts of the matter, and it must always be properly motivated. For me, the debate remains open. How Zuma's judgment will influence future contempt of court proceedings will unravel as we go ahead in law. In my view, the Zuma judgment was very unique, and the facts might not apply to all individuals. However, the golden thread remains. As the court said, nobody is above the law. In this case, firm action was necessary to ensure that the dignity of the court was restored. And this is exactly what the Concord did. The Concord took the lead in the protection of justice when it took a firm stance against Zuma's disobedience of the court orders. Thank you.
Thank you, Eliza. Interesting stuff. Can you tell us how the minority judgment differed from the majority judgment?
Sure. It's actually quite interesting. The minority and the majority judgment concluded that they came to the same decision that Zuma was actually in contempt of court, but they only differed in the end in the sentencing of Zuma and what was the proposed sentencing. The minority stated that the unsuspended committal of Zuma wasn't constitutionally justified.
All right. Okay, thank you. And then I just received another question from one of our clients via WhatsApp. I assume that they can't be here today. The question is, what does this judgment mean for contempt proceedings into the future when the courts will have to deal with non-compliance of a court order by the ordinary citizen, which of course is very relevant to our clients, I think, who spend loads of money in litigation, and you don't want to sit in a position where you're not able to implement your court order. Can you give us some comments on that?
Yeah, that's a very good question, actually. So I think the best way to answer that question is in two parts. First, you need to understand the common law requirements for contempt of court, and then the sanction that will flow out of the contempt of court. Insofar as the first part is concerned, the Concord in this matter did not deviate from the common law requirements. They kept in step with considering the requirements. The Concord nearly took it a step further when they considered the appropriate sentencing for Zuma's conduct. So I would say that the development came into in that section, and if our clients' matter or the facts fall within that scope, Zuma's matter will be very relevant. If aggravating circumstances are present and we as the applicant or defending an applicant's case have to bring a proper case for a punitive cost order, a punitive order. So if our client's matter falls within the scope of the Zuma judgment would likely have a great impact on the judge's decision on sentencing. But we will have to see how courts deal with the matter in future. We have seen a few unreported cases that the court is actually very strict with their sentencing, and they do impart a harsher sentence in matters where contempt of court is at play.
All right, thank you very much. I do recall a recent judgment which one of our partners were involved in, where the court ordered a 300,000 Rand fine for contempt of court, where previously I think the highest fine was not even a tenth of that. So yeah, very, very relevant, very interesting. And good news, of course, if you are the one seeking to implement the court judgment or the court order. Not so good if you are the one in default. I see there's another question that's come up. Eliza, says, you mentioned during your talk that there were 2 minority judgments. Are you able to you elaborate on one of them? On one of the 2 minority judgments, on how they differed to the minority judgment. Can you speak to the one that you didn't touch on, or perhaps just how the 2 minority judgments differed?
I can't recall exactly top of my head how each one differed, but it was basically 2 separate groups, if I understand correctly. But Demikoza, I can just respond to that properly when I've had a minute, just to orientate myself exactly what the 2 parts said. But they both concurred that the sentencing of the majority judgment was too strict with regards to the punitive order of direct imprisonment.
All right, I think that is all that we have time for today. I think another question has come in. Lisa, I'm going to ask you to please get back to Michelle Maguire after the session, just to give her some feedback.
Sure.
But yeah, it seems like the common law position has stayed the same, and where the developments have come in is where the court looked at sentencing, and that they much more firm in that regard. Thank you very much, Eliza.
Thank you so much.
Our next speaker is Mto Mapamulo. Mto has a CV that I think will take a day to read. For purposes of today, I'll just say that he is a senior associate specializing in business insurance, and that he'll be talking about the impact the pandemic and the recent looting episodes have had on the insurance industry. Thank you, Mto.
Thank you, Demi, and a very good morning to all the viewers and all the attendees. And thank you very much for joining us this morning. The past 15 to 20 months have been very interesting and there have been some very significant developments insofar as the insurance area of law is concerned. So I think it is quite apt and quite opportune that we take a closer look at some of the relevant legalities and the impact of a pandemic and looting on insurance claims. And that is what we are going to really look at during the course of the discussion. Just briefly, some of the points that I will look at, it will be the impact of COVID-19 on insurance, and we will also consider the related case law. We will then proceed to look at recent looting and unrest. Then just briefly touch on the determinative factors insofar as who bears the cost for the damage caused by the recent looting and unrest. between the insurer, says REA, as well as the insured businesses. Then we will proceed to look at the legalities for consideration when one starts or intends to institute such claims. I must point out that these will not be necessarily be discussed in this particular order. However, the flow of the discussion will direct us as to which points are being discussed at which point. Without further ado, then we need to look at the COVID-19 and the related case law. So when COVID-19, well, there was an outbreak of coronavirus, and the WHO declared this a pandemic. There had to be a response by various governments of various countries, and this in turn led to severe restrictions in movements as well as business interruptions, which ultimately led to a loss of revenue for many businesses. This then instigated, or rather triggered, business interruption policies that various businesses do have in place for such for such perils, and there was obviously a pushback by the insurers, which then led to a very vigorous and robust litigation. And worldwide, there's been this kind of litigation, and I must point out that in most instances, courts have come to the rescue of many businesses. And South Africa was not spared this kind of litigation, and it's been very interesting to see the developments in this regard. We have two prominent, or rather leading cases in this in this regard. One being the guard risk case, and the other being the one that you see on your screens, being the Ma-Africa Hotels against Santam. So basically, the facts on both cases are the same, being that there was business interruption stemming from coronavirus, as well as the subsequent lockdown, which led to loss of revenue for the businesses. So when these matters went to the High Court, the contention from the side of the insurer, it was that what led to the loss of revenue, it was not necessarily a coronavirus, which is an insured peril under identifiable contagious disease, but rather it was the lockdown or the government's restrictions. So what the court, the High Court held in both cases was that those two could not be disassociated, because in the absence of a coronavirus, there wouldn't have been the government's response in the form of the restrictions. So that was then in both cases, the insurers were disgruntled, obviously, by the outcomes, which then led to the appeals in both cases to the Supreme Court of Appeal. The guard risk case was heard by, or rather the SCA gave or handed down a judgment on the guard risk case towards the end of last year, being November 2020. And what the court said in that case, they basically confirmed the findings of the High Court to say that you cannot disassociate COVID-19 and also the subsequent lockdown regulations. So when this matter of the Ma-Africa Hotels, which by the way, the Supreme Court of Appeal gave the judgment last week, Thursday, the main issue really for this case was only confined to the indemnity period. So the question was basically in terms of the policy, there were two periods that were specified, being a 3 month indemnity period, as well as an 18 months indemnity period. So obviously, Santam was arguing that it had to the 3 months indemnity period was applicable, whereas the businesses were arguing that the 18 months were applicable. The court held that it had to be the 18 months, and the court did make a remark to say that there may have been an ambiguity in the policy wording in terms of the indemnity period. However, any ambiguity in the policy had to be construed in favor of the insured business. And the reason for that is because the insurer is responsible for the drafting of the policy, and then they've got the responsibility to minimize and also just to ensure that there are no ambiguities in the policy. So that is where we really are in terms of case law insofar as COVID-19 is concerned in relation to the insurance business interruption cases. Then there are instances, or rather there are cases where that have not gone to court, but rather there are still settlement negotiations. Unfortunately, some businesses have not been able to claim successfully for various reasons. The most prominent ones would be things like time-bearing clauses. So in these kinds of policies, it is quite important for businesses to have a look at their policies, look at the time-bearing clauses, which are quite prominent in the insurance policies. So you are given a certain number of days or a certain number of months within which you should lodge or submit your claim, because failing which you cannot be able to claim. And also in some instances, you do find that the business is indeed insured for business interruption. However, that business interruption has to relate to a specific peril. Say your business has been interrupted by fire, or there's been theft or looting for that matter, and you are not necessarily insured for identifiable contagious disease. And in that instance, then you will unfortunately not be able to successfully succeed with your business interruption in relation to COVID-19. And in some instances, there is room to take these matters to court or any other dispute resolution platforms, which I think also deserve some brief discussion, the dispute resolution platforms. And I know for most businesses, the cost as well as the duration do play a huge role insofar as the decision on a dispute resolution platform is concerned. So those two bullet points in relation to dispute resolution platforms and cost and duration will be discussed simultaneously. So it is always sagacious to start by looking at the settlement and negotiation. And that is quite cost effective and also time saving. You may also want to consider the mediation, which is also time saving and also very cost effective. Sometimes it may be ideal to go the arbitration route, which is not so cost effective. However, it can be very time saving, and the other benefit of this route is that you do get a ruling by an arbitrator, and then the most obvious one is the court litigation. The complexity, the nature, the facts, the circumstances of the case do determine the cost as well as the duration insofar as litigation is concerned. Then if we look at looting and also the recent unrest, there has not been any case that I am at least aware of insofar as that is concerned. However, given the scale of looting that we saw mid-year, one can realistically anticipate that there is going to be some vigorous litigation in that regard. And CESRIA is at play here, and also the insurers are also quite pertinent. So although there hasn't been any case stemming particularly from this recent looting, there are certain factors or rather legal principles that have been developed by our courts throughout the years, which may find application and which will be important for businesses if and when they want to institute claims in this regard, or rather to instigate litigation. So some of these factors would include things like the court as a point of departure. It is always almost always the policy wording. So the court would consider that. They would also consider the element of good faith. They would also consider the overriding intention of the policy, which is to ensure the insured business for a specific peril. And in this regard, your policy will have to make provision or an extension for CESRA cover. And we also look at the exceptions in relation to that in relation to that clause of CESRA. So those are really some of the factors, though this is not an exhaustive list. These are some of the factors that will be quite pertinent when these cases come. And insofar as the COVID-19 ones are concerned, it will also be interesting to see if there will be any appeals to the Constitutional Court, because this is obviously matters of public interest and also for businesses. So insofar as COVID-19 and the recent looting, these are really the factors and also the legal principles applicable, as well as the case law. And I think that is just about it insofar as this topic is concerned.
Thanks very much, Mto. You touched on the importance of time barring clauses. Do all insurance policies have those? And what's the implication if it's absent?
Thanks, Demi. Well, they are quite prominent. But it's not every policy that would have these kinds of clauses. And in the absence of a particular or specific time barring clause, then your normal prescription act will be applicable, which is ordinarily 3 years.
All right, okay. And then I saw on your slides that you mentioned something about broker liability, but I'm not sure if you got to touching on it. It might have been on due to time. Can you just tell us under what circumstances would a claim against the broker arise?
Okay, that will really depend on the facts and the circumstances of the case. However, just a practical example, say in your initial policy, you were covered for infectious and contagious diseases. However, in your subsequent renewals of your policy, your broker did not specifically point out that they've now removed that clause. And you now find yourself in a situation where you want to claim for business interruption relating to COVID-19. And you were never informed by your broker that they've now eliminated this particular clause. In that instance, there may be a claim on a common law duty of care, because brokers do owe that common law duty of care to the insured businesses to ensure that they are reasonably and they are reasonably covered, and the insured business is aware of what they are covered for.
All right, interesting stuff. I did not know that, but I'm happy to know it now. There's one more question from Tembi Kosa. She says, are the remedies also available or accessible to small business owners, or is it only those businesses covered by an insurance?
Well, to be covered, you must have an insurance policy in place. Otherwise, you will not be covered. In very rare instances where it may be possible to, well, specifically in relation to the recent looting, as much as it is quite a stretch to say you can, in some instances, justifiably try to sue, say, the Minister of Police But the facts of the case, well, the facts of the case and the details will really determine. But if, well, it is always safer if you are covered. And I also read something where the government did commit to assist small and medium businesses who may not have the relevant insurance policies in place in relation to COVID-19 and also in relation to the recent looting.
All right, interesting stuff. Thank you very much for that.
Cool. Thanks, Demi.
We now turn to the last topic of the day, which will be presented by Portia Manzini. Portia is a senior associate in our commercial litigation team, and she is joined by Professor Casey of UCT and Ms. Ziko Pali, the co-founder of Cura Medical. Both of them are leaders in their fields. Portia, over to you.
Thank you, Demi. This topic is one that is quite dear to my heart as it looks at leadership in Africa with a special focus on African women leaders. So through this panel, we'll be looking at women who are in leadership positions who, despite the many challenges they have encountered within the past 18 months, have still managed to steer their institutions into favorable positions. While the past 18 months have been undoubtedly tough and challenging for most leaders, there have been noteworthy moments where we saw women changing history. One of those moments was when we saw Madam Kamala Harris being appointed as the first female vice president of the United States. So throughout this discussion, I would like you to think of such powerful women, women who teach and inspire other women to not only be pioneers, but also trailblazers in their respective fields. Ladies and gentlemen, please allow me to introduce to you Ms. Ziko Pali and Professor Casey, whom I hold in high esteem.
Hi, Portia. I'm sure I'm not the person that you want to see. There we go, Professor, welcome. We are just waiting for Ziko Pali. There she is. Take it away.
Thank you, Demi. Ms. Ziko Pali is a co-founder and chief operating officer of Cura Medical. Prior to establishing Cura Medical, Ziko was an attorney at one of the law firms in Sandton. She holds a master's degree from Harvard University and an LLB degree from Wits University, which is where I first met her as my senior and tutor some 10 years ago. Professor Casey is the current Dean of Humanities at the University of Cape Town. She holds a PhD in psychology from the London School of Economics and Political Science and has been a senior lecturer at UCT for approximately 10 years. Ziko, perhaps you would just like to let the audience know who you are and about the role that you play at Cura Medical.
Good morning, Portia, and to your attendees. My name is Ziko. I am the co-founder and chief operations officer at Cura Medical.
Yeah, thank you, Ziko. Professor Casey.
Good morning, everyone, and thank you, Portia, for the invitation. So I'm a social psychologist. I'm associate professor in psychology in the department at UCT, and also at the moment currently serving as Dean of the Humanities faculty. I came to UCT in 2011 and developed an interest for academic leadership, and before my current position, I was Deputy Dean for Transformation. Yeah, so that's me in a nutshell. Thanks, Portia.
Thank you. Ziko, if you can just perhaps expand a bit on what it is that Cura does and when it was founded.
Thanks, Portia. Cura is a technology company specializing in remote patient monitoring solutions. The company was founded in 2018 by me and my two co-founders, Dr. Vuyani Mhlomi, who holds an MBCHB from UCT and a PhD and MBA from the University of Oxford, as well as Dr. Rob Cornish, who holds a PhD in machine learning from the University of Oxford. Our flagship offering is our tech-enabled hospital at home solution. You'll probably be aware that there are a number of home-based care organizations that have popped up over the last couple of years, but none of them have really had the capabilities to care for acutely ill patients, and that's because they lack the monitoring technology that is required to care for such patients. So despite hospitals proving to be an increasingly suboptimal environment for a subset of patients, absent an alternative, those patients would have to be cared for in the general ward, even for simple things like monitoring or intravenous therapy or treating a pneumonia. Enter Cura Medical. We bring all the essential elements of hospital level care to the patient's home. So in addition to home visits by qualified health professionals, we've developed a platform that allows for all of the vital signs and parameters that would ordinarily be monitored in the hospital, in the patient's home. So the way that it works is, as you see on your screen, we leverage a couple of wireless clinical grade biosensors that attach to the patient's body. Those biosensors transmit data, so in the form of vital signs and certain parameters like posture and steps, all the way through to a relay device, which is really a customized phone, to a cloud, and that data is visualized 24/7 and in real time by a team of qualified health professionals that is housed in our clinical command center. So by bringing all of these elements together, we are essentially in a position to care for most patients who would ordinarily end up in a general ward in the comfort of their own home. The thing that I would highlight here is instead of buying off-the-shelf software from Europe or the US, we've developed our platform in-house and for the South African context so that it's resilient to things like load shedding. And that has really helped, especially over the last year. The last thing that I would note is our services are reimbursed by at least 90% of the medical schemes in South Africa. And I guess our most recent show of faith has been the acquisition of an equity stake in our company by Life Healthcare Group.
Oh, wonderful. I mean, that sounds like it's technology of the future, but in our current times. And I think, Professor Casey, you can take pride in knowing that one of the co-founders is a former student at UCT.
Yes, that's fantastic.
Yeah. So, Professor, perhaps maybe you can just let me know what challenges did you face in your role as the Dean of Humanities when the COVID-19 pandemic started last year?
Yeah, I think it's been a challenge for all universities across the country and globally, really, because when the pandemic hit, we had to close down the university, for a period of time, and send all our students home, and we started working remotely, so our staff have also been working from home. And gradually, over the past 18 months, we've been reopening teaching spaces and workspaces. But I think it has been very challenging on academic staff, for instance, who have had to, restart over with rework their curriculum and teaching practices. I think many people feeling overwhelmed and overburdened with work. And for students as well, I mean, it's been tough for them to be able to find spaces for studying and also to have access to data and laptops and those kinds of things. So we have seen a lot of students dropping out or feeling isolated. So yeah, it's been a really difficult time. but we're still teaching, we're still open, and I'm hoping that by next year we'll be returning to a lot more face-to-face classes.
Certainly. I mean, I think we want that. We want our students to learn, and we want the university to stay open. But that wasn't just your only challenge last year or this year. You've also had the wildfires affecting the university. I mean, we saw a video of that. If we can just have the video up for the audience to see. So that was the video, and I think we can see how badly burnt the library was there. These are all challenges that you faced within a very short space of time after ascending to your deanship. How do you overcome that?
Ooh, that's a good question. I think we're still working through it. I think what has been, it was a really devastating time, and we lost a lot of materials. So, it was the African Studies Library, which is kind of the heart and soul of the university. So we were very devastated about that loss. But I think what was really helpful was that there was so much support coming from the Cape Town community, from local businesses who housed our students and fed our students, and also universities across the world who have been helping us to rebuild our archives. So yes, it's a very challenging time. We're still struggling on many levels, especially for students and staff whose research works with those archives. I mean, it's going to take a while for us to rebuild that. And some of our master's students and PhD students are going to have to, spend a little more time at university finishing off their degrees because of that loss. So we're still working through the challenges, but we would never have been able to do it alone. It was really heartwarming to get the support from the Cape Town community in particular, but from universities across the world.
Oh, thank you. I'm really grateful to see that there is progress, and that, I mean, the university, although it was disrupted a bit for a week or so when the academic year was put on hold, but you seem to have picked up quite nicely, and the university is fully functioning with the assistance of the communities that you've mentioned. I know, Zico, you haven't had fires at Cura, but I'm sure you've also had challenges, with starting your business just before the pandemic started. So what other challenges have you guys faced, and how are you overcoming those?
Yeah, no, thankfully we haven't had real fires, but the one thing I would note is the company was founded in 2018, but we were sort of in an R&D period from that period to say last year. And our plans, alongside our investors, were to only launch our offering in Q1 of this year. So when the pandemic hit, we just felt that we were sitting on technology and an offering that could really help to decant hospitals at a really desperate time. And so we decided to accelerate the launch of our offering, which was, of course, very difficult in the middle of a pandemic with supply chain challenges. It made, decisions very difficult. And that, in and of itself was quite challenging. Some things we got right, some things we got wrong, despite our overall success. So yeah, I think that was the biggest thing for us. We pride ourselves in making data-driven decisions, and we found ourselves, because we've never been in a pandemic, we found ourselves in situations with very limited data and having to make, really critical decisions over that time, which was quite challenging.
I can certainly imagine that, but I think what I'm getting from the two of you is that, for leaders, what is important is adaptation, being able to adapt to your environment, to the changes in your environment quite soon and swiftly. And also that unity is very important, not only in the organization itself, but also with the company and the community that it serves. I guess, as people who are looking at leaders, we should be looking for people that have strengths to adapt, and people who can recognize an environment that requires strengths that it do not have, and be able to ask for assistance when they need it. Okay, thank you. And then what I want to share is there's a quote from our former Vice President, Madam Phumzile Mlambo-Ngcuka, that says the more responsibilities you take, the more you realize that there is more to learn and that you do not know everything. So within these challenges that you have faced and how you've overcome them, what are the key things that you have learned about yourself and the leadership within your institutions? Zico, perhaps you can answer.
Sure, that's a good one. I think the one thing I've learned about myself and my colleagues in the leadership team is that we are incredibly resilient. Sometimes, like I said, you will get things wrong. And when you're in our space, there isn't a lot of time to wallow and feel sorry for yourself. You kind of have to get back up and try again. So I think resilience has been the biggest lesson, both about myself, but also about my colleagues.
And Professor, you are nodding. I think perhaps you share the sentiments.
Yeah, absolutely. I mean, it's not the first crisis that we've had in recent years at UCT. I mean, we had roads must fall, fees must fall. And it almost feels like, to be a leader in an academic institution, you need to, crisis management is part of our job description now. But I think it's also about being patient. I think both of us work in quite large bureaucracies and, in an environment where you've got to adapt to changes quickly, and it's often not possible because of our systems and policies. And so I think I've learned to be patient. But I think one thing that's really important is also to lead with courage. There's a lot of changes that need to happen, not just because of things like COVID, but when an environment where especially universities like UCT, which were historically white, there's a lot of changes that need to happen, that have happened, that still need to happen. And I think you got to be quite courageous and empathetic, because a lot of people, there's a lot of polarization that happens often amongst staff and students when change happens. So you got to be empathetic to people, because not everybody is ready at the same time for these changes. And I think our responsibility is to keep communication open, to keep a sense of collegiality and belonging for everyone. So I would say patience, courage, integrity, and empathy, I think, are some really important qualities to get us through these different ups and downs.
Thank you, Professor. A lot of what you're saying now just resonates a lot with me. You know, I think when we look at the parts that you and Zico have taken, one can see that they aren't easy parts, but somehow you have managed to do it with such ease that it doesn't look like, you know, it's a crisis management project that you're running. It looks flawlessly from the outside. And, you know, that is inspiring to me. And I think many of the audience will also be inspired to put their hands up for leadership roles. And, you know, for the current leaders to open up more spaces, especially for women, because I do believe that, you know, the table is big enough for all of us, and there should be a chair for more women as well.
Absolutely.
Thank you. We can just take Q&A if Demi has questions.
Sure. I was just, I beg your pardon, I was just struck by the almost quote, leading with courage, empathy, integrity, and patience. I think that's certainly something that we would all want in leaders and that we can all strive to be. So thank you for that. We do have a few questions that's come in. To you, Zico, can you please elaborate on the costs of your virtual treatment or monitoring compared to the costs of hospitalization?
So depending on the event per patient, we're looking at savings anywhere between 30 to 50%. You can imagine it is significantly cheaper to a hospital stay because we've eliminated all of the hotel-like costs, which are, you know, a substantial part of what you eventually pay if you are staying sort of in a general ward.
Mm-hmm. Yeah, yeah, it's incredible that it's now possible. And thank you for paving the way. Professor Casey, UCT has retained its spot as the #1 university. I can't remember even for how long, for a number of years, in not only South Africa but in Africa. What would you attribute to that success?
I think it's a great university. I mean, I think our academic programs are very high quality, and you know, I would want to say, just to keep into the theme that Portia's started, is that we are transforming the university very rapidly. And in our faculty, for instance, the number of staff from, you know, one of the student demographics have changed completely in the last 20 years. And so we have majority Black students now. But in terms of staff demographics, that's been a lot slower, but I think it's changing quite quickly. And I think that's really important in order to keep being innovative, doing research that's relevant, producing knowledge that's relevant. We need to be able to change who's actually doing the research, who's teaching, and who's coming out with degrees. And I think that we've put in a lot of effort at UCT in that direction. And I think that's what keeps us quite competitive on the national and global stage. I would also say that, you know, UCT traditionally has been one of the better resourced institutions in South Africa. So that also contributes a lot to what we can do in terms of maintaining a high quality education and high quality knowledge. So I think it's a combination of that and what we've done internally to transform the institution.
Well, I think that's a very valid point, and I think that we must bear that in mind. I see that we have a minute or two left, and this conversation to me was just too short. So let me just allow me to ask one more question directed at you, Zico. You faced a number of challenges but I'm sure it's not going to stop you from doing more and from breaking more barriers. What's next for Cura Medical?
Can you hear me?
Yes.
Great. So what's next is scale. We are actively trying to entrench our presence across the country. And then soon thereafter, because the pressure is increasing for us to do so, we intend to expand across the continent.
All right, very exciting. Thank you to our panel for the thought-provoking discussion. I really found it very interesting. We must have more of these conversations. And then thank you to all of you, our guests, for staying tuned. We've reached the end of our session, and I hope that you found it useful and that you were able to take away some practical tips. Please take a moment to complete the very short feedback survey, which I think will be posted in the chat box below. It will also be emailed to you. We'd really appreciate any input that you may have to help us make next year's Crammer even bigger and better. And then last but certainly not least, please join again tomorrow. Same time, same place. Lita Miti Komata, who is no stranger to Crammer, will be your host, and she will be joined by partner Danny Doman and 3 guest speakers. You can expect insights into recent trends in the patent litigation space and the commercialization of new ideas. Stay safe, everybody. Cheers.